Okay, let's unpack this. The whole conversation around U.S. immigration enforcement, it feels like it's shifted, doesn't it? It's not just about a broken system anymore.
No, not at all. The narrative we're seeing now, especially from a conservative viewpoint, is that the system wasn't just broken, it was intentionally dismantled, burned down, essentially.
Right. And the focus now is on rebuilding something totally new from those ashes with really aggressive action.
Exactly. That's the ideological core driving what we're seeing. It's this demand for restoring the rule of law, but through, well, pretty sweeping measures that put public safety and American workers first.
And this isn't just talk, is it? We're seeing concrete examples of this aggressive stance playing out right now. For you listening, there are a couple of key things happening that really highlight this push.
Definitely. First, you've got the Supreme Court. They recently gave a temporary, it was a 6-3 split, very ideological, allowing ICE raids to start up again in California. That's a big signal.
Overriding state objections, basically.
Precisely. And second, maybe even more striking, is the use of this really old law, the Alien Enemies Act from 1798.
1798, wow. How are they using that today?
And they're targeting alleged members of this Venezuelan gang, Tren de Aragua, for mass deportation using this act.
Using a law that's over 200 years old against a modern gang. That sends a message, doesn't it? It's like they're digging deep into the legal toolbox.
It absolutely is. The 1798 Act gives the executive huge power over non-citizens during hostilities or perceived threats. Pulling it out now against this specific group, it's meant to be a clear warning.
The message being
That if you're seen as a threat, it doesn't matter how complex your situation is, the government will find a way, find the authority to remove you. It's about projecting absolute control and order.
Okay, so let's dive into that idea of restoration. The critics of the previous approach, they don't just say it was inefficient, they use strong language like deconstructed. What's the actual evidence they point to for that claim?
Well, they focus on specific administrative actions, things that, in their view, deliberately blurred the lines between legal and illegal immigration, like waiving laws Congress passed or creating benefits without authorization.
Is there one specific policy change that really crystallizes this argument for them? Like the smoking gun?
Yeah, I think the clearest example they cite comes directly from DHS guidance under Secretary Mayorkas. He stated quite explicitly that just being unlawfully present in the country, that alone wouldn't be enough to trigger enforcement action.
Wait a second. If federal law says unlawful presence is grounds for deportation, how can the agency just decide not to enforce that? Isn't that undermining the law itself?
That's exactly the argument from the restoration viewpoint. They see it as Mayorkas effectively trying to rewrite the law passed by Congress. They argue that unlawful presence is the legal basis for enforcement.
So if the administration chooses not to act on that basis?
Then, critics say, the system fundamentally breaks down. By saying unlawful status isn't a sufficient trigger, they argue the previous administration basically manufactured a crisis of non-enforcement, intentionally.
Okay, so if the old policy created this pile of ashes, as they put it, the restoration mandate has to be just as comprehensive. What's the philosophy behind rebuilding?
It's about replacing that permissive framework with something very hierarchical.
Yeah.
The guiding principle is Americans first, legal immigrants second, and illegal aliens. Well, not factored into the benefit structure at all.
And the core idea is that Congress makes the rules, not the agencies.
Right. Congress alone should decide who gets admitted and under what conditions, not the administrative state making its own rules.
Which leads us to deterrence. If the perception was that it's easier or faster to come illegally, the new approach aims to flip that calculus entirely.
Absolutely. The sources really emphasize this. A lawful system, they argue, needs full, consistent enforcement. Without that, without making the illegal route visibly punitive and more difficult than the legal one, future migrants won't be deterred.
So the consequences have to be clear and consistently applied.
Exactly. That's seen as the only way to genuinely incentivize legal pathways and disincentivize illegal entry.
We've got the philosophy down. Restoration through enforcement. Now, let's get into what's really fueling this push the link between immigration and public safety concerns. This seems to be where the political heat is most intense.
Yeah, the conversation definitely shifted. It went from policy debates to, frankly, public anger, often sparked by really tragic, high-profile cases. The link between border security, or lack thereof, and public safety is now a major driver for many voters.
And the murder of Laken Riley, the nursing student, seems to have been a flashpoint for that specific concern.
It really ignited things. That case became a national symbol, fueling warnings about crime linked to illegal immigration and pushing aggressive enforcement right to the top of the agenda.
And the polling reflects this anxiety.
It does. Surveys show a majority of Americans are alarmed. And quite strikingly, something like 6 out of 10 voters now say they support mass deportations as a way to restore order. That's a significant number.
Are there specific stats fueling these concerns beyond anecdotal cases like incarceration rates?
Yes, there are reports looking at federal assistance data. They found, in some states, that illegal aliens were significantly more likely to be incarcerated than legal residents.
Like where?
For instance, twice as likely in New York and almost 5 times as likely in Arizona, according to those specific reports. When you pair stats like that with violent incidents, it really strengthens the argument that this is a direct safety crisis needing urgent, strong action.
Like those mass deportations we talked about earlier, targeting specific groups.
Right, like the Tren de Aragua crackdown. These high-profile actions are designed to do 2 things: remove immediate threats and send that very public deterrence message, leave or face serious consequences. It has to be visible.
And it's not just border states seeing this ramp up in enforcement, is it?
No, definitely not. Federal initiatives are moving into the interior. We're seeing task forces like the one in Memphis combining FBI, ICE, marshals, even the National Guard to tackle urban violence. And the sources suggest plans for similar crackdowns in places like Chicago and St. Louis.
But when you move enforcement inland, you run straight into the issue of sanctuary cities, right? That creates friction.
That's a huge roadblock. Sanctuary policies explicitly prevent local police from cooperating with federal immigration officers. Critics argue this shields criminals, even repeat offenders, undermines deterrence, and puts the public at risk.
And we're talking about a lot of people federal authorities are trying to locate in these areas.
The numbers are pretty staggering. DHS has put states like New York, Illinois, California on notice, essentially. ICE's own records show over 662,000 immigrants on their non-detained docket, people not currently locked up, who have criminal accusations or convictions.
662,000.
Yeah, and that includes over 62,000 convicted of assault. These are individuals ICE is trying to deport, but they often hit a wall because local jurisdictions won't cooperate.
That federal versus local clash really highlights the legal maze here. Let's pivot to those rule of law challenges, not just for agencies, but for individuals and especially for businesses trying to follow the rules. That Supreme Court decision on California raids seems like a perfect example.
It really is. The court's temporary ruling allowing ICE raids to resume, pending the full case, sparked immediate backlash. Opponents, like the California governor and LA mayor, called it un-American, raised fears of racial profiling, targeting Latinos specifically.
And the legal heart of the matter for an officer on the street is what constitutes reasonable suspicion to stop someone. That seemed to be the court's dividing line.
Exactly. Justice Kavanaugh tried to draw a line in his concurring opinion. He said ethnicity alone isn't enough for reasonable suspicion. But crucially, he added that ethnicity can be a relevant factor when combined with other things, behavior, location, etc.
But that distinction sounds difficult to apply in practice without potential bias creeping in.
Well, that was Justice Sotomayor's big concern in her dissent. She warned about the practical reality, arguing the ruling could effectively allow targeting anyone who looks Latino, speaks Spanish, and appears to work a low-wage job. It shows just how hard it is to enforce these laws fairly on the ground.
Okay, let's shift to businesses. They seem caught in this regulatory vice, especially with employment verification and the I-9 form.
Oh, the I-9. It's kind of a perfect example of regulatory complexity meeting punitive enforcement. The form itself is just 4 pages, seems simple enough, but the instruction manual, it's over 130 pages long.
130 pages for a 4-page form.
Yeah. Think about a small business owner trying to digest that. Just to hire someone legally, it's immense.
And the real trap is in how they're supposed to check documents, right?
Exactly. Employers have to accept documents if they look reasonably genuine on their face. But, and this is key, they are strictly forbidden from asking for extra proof, even if they suspect something's off.
So if they ask for more proof to be safe, they risk trouble.
They risk a discrimination lawsuit from the Department of Justice. But if they accept documents too easily and miss something, they face huge fines from ICE. It's a classic catch-22.
And this is where the government gets massive leverage.
Absolutely. because the penalties for simple paperwork errors, forgetting to check a box, putting a date in the wrong format, can be stacked up. Thousands of dollars per form.
Even if every single employee is actually authorized to work.
Even then, a business could have a completely legal workforce but face crippling fines just from minor clerical mistakes on the I-9s. This gives the government huge power to force settlements because fighting it is just too expensive.
So for a small business owner, the whole idea of judicial review, the rule of law protecting them, it feels not real.
The sources use the phrase more ephemeral than real, and that feels accurate. Small businesses just don't have the money or time. Estimates are $80,000 to $100,000 in legal fees just to get a hearing before an administrative law judge.
Just to start the fight.
Right. So the cost and the delay mean it's often cheaper, more practical to just pay the fine to endure an injustice than to contest it, as one source put it. The system basically forces compliance through the threat of financial ruin.
So what are the proposed fixes for businesses stuck in this mess?
Two main things come up consistently. First, mandate E-Verify for all employers, nationwide. The thinking there is that E-Verify is essentially game over for illegal immigration, employment-wise.
Because it cuts off the jobs magnet instantly.
Exactly. If jobs dry up because verification is instant and electronic, the incentive for illegal entry plummets, leads to self-deportation, theoretically.
And the second fix targets that issue of legal fees, the Equal Access to Justice Act, EAJA.
Yeah, EAJA is supposed to help small businesses recover attorney fees when they successfully fight the government. But there's a big loophole.
Which is?
The government can lose the case but still avoid paying the business's legal fees if they argue their position was substantially justified, even though they lost.
So the business wins, but then has to fight again just to get reimbursed.
Pretty much. They have to relitigate the whole thing just for costs, which most can't afford. Plus, the current cap on what attorneys can be paid under EAJA is stuck at $125 an hour, which is, way below market rate.
That really paints a picture of the challenges on the ground. Okay, as we wrap this up, we have to acknowledge the sheer scale, especially the financial scale, of what this aggressive restoration vision actually requires.
Yeah, the ambition is huge, but the price tag is, well, equally huge. Experts estimate Congress would need to find something like $185 billion in new funding just to fully resource this kind of deportation program.
$185 billion for what specifically?
By hiring thousands more ICE officers, more immigration attorneys, building significantly more detention capacity, expanding the immigration courts, the whole infrastructure needed to process and deport people on a massive scale. It's a colossal undertaking.
And just using executive actions isn't enough for long-term change, is it? If the goal is permanent restoration, they need laws passed.
Absolutely. Executive orders can be undone by the next administration. For lasting change, they argue, you need Congress to act. That means mandating E-Verify nationwide, not just encouraging it.
And the other big legislative piece?
Clarifying the 14th Amendment to end what's called universal birthright citizenship, the automatic citizenship for anyone born on U.S. soil, regardless of their parents' legal status. That's seen as crucial for long-term restoration by proponents.
So if the overarching mission is restoring order and prioritizing citizens.
It really brings up a final, maybe provocative question for you, the listener, to think about. Given these enormous costs, financial, legal, social role, just to try and enforce the existing laws and get a handle on who is within the borders.
What does it cost America, fundamentally, not to even know accurately how many citizens it has? And taking that further, should the next census change its methodology? Should it count only citizens when deciding how many congressional seats and electoral votes each state gets?